we're about to start this very interesting webinar, I think, in respect of the relationship of mediation to judicial review claims. And my name is Tim Baldwin. I'm a member of the Garden Court Public Law team, and I'm going to be chairing this webinar. And briefly, the speakers that we're going to have this morning from our expert mediation team are David Watkinson, Margaret Doyle, and Helen Curtis, all of the Garden Court mediation team. And just to introduce this webinar, each speaker is going to speak, mainly David and Margaret, for about 17 minutes in total. Then Helen is going to finish up the webinar with about a 5 or 6 minute short talk. And the issue, what we're considering today, is the potential role of mediation in public law and judicial review litigation. Many people might think, well, it can't really have any role because judicial review and public law deal with hard issues of law. There's no room to mediate, settle, or discuss complex public law legality points. However, it's understood that the Ministry of Justice and the Administrative Court are now interested again in how mediation may apply in judicial review claims. And also it's understood that the Administrative Law Bar Association may be consulting with its members shortly on this issue. We don't have any idea whether that's going to happen or the dates when that is going to occur. So what we've decided amongst us to assist this potential debate and to revisit this important issue is that the speakers today will be discussing the pros and cons of the use of mediation and the practical steps, including cost considerations in the use of mediation in public law and judicial review claims. My personal experience of judicial review and mediation has been both in the social welfare sector, mainly in community care cases, often post-permission when the court has granted permission for judicial review, and the community care issues are particularly knotty, and often the application of local policies are also at issue. And sometimes mediation at that stage can create solutions that go to settlement and remedies of the case. Whereas I've also been involved in planning cases where the issues are more commercially orientated, and there's a completely different feel to the approach in my experience about judicial review and mediation, but it still occurs. So we aim in this to give you a better understanding of how mediation might be used in judicial review cases, primarily in the social welfare sector, and whether in fact there is a place for mediation and what value or added value, if any, it can bring, with reference to some specific examples. Just to let you know that this webinar is being recorded, and we'll be sending out slides and a recording link to all of those who've registered. And if you have any questions during the talks, please put them in the Q&A box that should be available on the bottom of your screen. We aim to finish at 2 p.m, but we hope to have time for questions and answers at the end. We ask you not to turn your microphone on during the recording, because that can cause feedback issues. So turning to our speakers, we have 3 excellent speakers today. I'm really pleased that they found time to agree to do this webinar. First off, we'll have David Watkinson, who will deal with the practicalities of mediation, what who is involved and what steps to take. Margaret Doyle on what research has already taught us and what it could offer in certain circumstances. Then Helen, sweeping up at the end, will deal with cost issues for a few minutes. So introducing our first speaker, and that's David Watkinson. David, as well as often being mistaken for Erling Haaland these days, the lead striker for Manchester City and champion goal scorer in the Premier League, is also a founding member of Chambers, and he was joint head of Chambers, and he practiced as a barrister in large swathes of cases for about 40 years. Now, since his retirement, he qualified as a mediator, and he's adapted his skills to assisting parties in disputes to discover solutions for themselves that's acceptable to them. So he's represented people in mediation, but now he's focusing on mediating disputes, and he regularly writes for our mediation blog. So to kick things off, our big man up the front, David Watkinson.
Right. Thank you very much, Tim, for that introduction. So I am going to deal with the advantages and disadvantages of mediation in a judicial review case, the stages at which mediation can be used, the application of mediation to different types of judicial review cases, and what is practically required for a mediation. So here we have what the Judicial Review Pre-Action Protocol says about alternative dispute resolution, which includes mediation, of course. You can see that it states that litigation should be the last resort. Parties are required to consider whether some form of ADR would be more suitable for litigation, that is. That evidence of consideration of ADR may be required by the court, and failure to consider can have consequences in costs. Please note, this is not on the screen, but the PAP identifies 4 methods of ADR. First of all, negotiation. Secondly, complaints procedures. Thirdly, ombudsman. And fourthly, we get to mediation, which the protocol defines as a form of facilitated negotiation assisted by an independent neutral party. So here we have the advantages of mediation in judicial review. And the first advantage is compliance with the pre-action protocol. But the second advantage is the final resolution of the dispute. If the mediation is successful, the parties come to an agreement which settles the whole dispute and is enforceable. And as the parties have come to an agreement, the dispute stops there. There will be no appeal. Faster resolution of dispute, possibly. This will depend to some extent on when the mediation takes place. If it happens shortly after a successful permission application, then the stages of filing of evidence, the time lapse between the grant of permission and the full hearing, and the full hearing itself are all avoided, not to mention, as I just said, the prospect of appeals. Also, by that stage, the issues should be clearer to the parties. Please note, it does take time to set up a mediation. Parties must agree to mediate. They must agree who is to be the mediator. They must arrange a location and a date convenient to the parties to attend, and all those others who may need to attend the mediation. I have known a mediation be set up within a day, but it was a bit of a hectic experience. Next advantage, saving of cost, again, possibly. As civil proceedings go, and contrary to public perception, judicial review, in particular in relation to High Court cases, is relatively cheap. Judicial review, it generally lasts for 1 day. There's no witness evidence. The emphasis is on legal argument. But mediation is likely to be cheaper. Lawyers are not required to prepare for a mediation as they would for a full hearing. You could even dispense with counsel for use at a mediation. And if the mediation is successful, further costs are avoided. Next, a mediation avoids stress of the court appearance. Even with a JR, where the client is not required to give evidence, and it's the clients I'm thinking of at this point, even at a JR, the client is still suffering anxiety, uncertainty as to the outcome of the case, and lack of control. His or her fate is being decided over his or her head. Next, mediation avoids, if successful, avoids the risk of loss of the case and of costs being increased. And finally, a successful mediation avoids an adverse finding on a matter of law, particular interest perhaps to defendants. So here we have the disadvantages of mediation. Firstly, delay, possibly, and this can be a disadvantage, particularly at the early stages of a judicial review claim. Before the letter before claim, after the letter before claim, but before issue, and before the application for permission once there has been issue. It's a disadvantage because the time limits for issue of a judicial review, as is generally known, are strict. 3 months from the date when the decision challenged occurred. In practice, it is most likely mediation or ADR will be considered after the permission hearing and grant of permission. But a significant number, and Margaret will tell us more about this, occur between the issue of the claim and the potential permission hearing. Costs, extra cost I put there. That is because taking on board what I said earlier, it does cost to settle a mediation, the cost of the mediation itself. And then the next disadvantage may be considered to be if it brings about a concession of error of law on the part of the defendant. It's looking at it from the defendant's point of view, of course. And a concession of error of law is involved because all judicial reviews allege that the decision made erred in law, although on various grounds. Whether there was an error of law is not at first sight an easy matter to compromise on, as Tim suggested earlier. Either there was an error of law or there was not an error of law. And defendants may be reluctant to concede an error of law, especially if a point of principle is involved. Also, the settlement order the court is invited to make must state the grounds relied on by the parties to justify the judge making the order. That's provided for by the practice direction, the CPR 54, paragraph 16. So it looks as if a settlement may involve a concession. But consider this. First of all, a consent order or agreed order is not a precedent. 2, the error of law involved may be specific to the case. 3, the order could be phrased as a withdrawal of claim on terms that the defendant reconsider or reverse the decision, or include other terms which a court might not be able to order, especially when compliance with the agreement require being set out in particular detail. This can particularly apply to community care or planning cases, for example. And lastly, I put dispute of law not determined. Now, this can be a disadvantage because the parties might want a final ruling for the court on a controversial issue or matter of principle. For example, the deportation to Rwanda of asylum seekers cases currently before the courts. However, this aspect might be said of any settlement, even a settlement when no mediation or ADR has been involved. But such settlements do take place. I'm going to spend a few moments on the different classes of cases in which mediation may be useful. The limited experience so far suggests that mediation is most appropriate in cases concerning individuals with particular specialist needs, whether it be a place in a particular school or a particular provision in a school, or a person with particular disabilities who requires specialized assistance, maybe in adapted accommodation, or a homeless applicant or an applicant stuck on a housing waiting list who require a decision refusing assistance to be reviewed or reversed, or a revised housing needs assessment and reallocation to a higher level. These are cases of particular individual need, but in principle, judicial review could take place in any type of case. So we come to the practical steps. I've already hinted at these, but first of all, what I want to look at is the role of a mediator and nature of a mediation. The very first point to get firmly in mind is that a mediator is not an arbitrator or a judge. A mediator makes no rulings. The mediator hears no evidence. The mediator makes no findings of fact and expresses no view as to the outcome of the claim as to who is right and who is wrong. The mediator does not advise either party. That is what the lawyers are there for. So you might be wondering by this stage, what does a mediator actually do? Well, the mediator is a facilitator. The mediator assists the parties to come to a settlement. The mediator enables the parties to look into the abyss, to consider the strength of their cases and the weaknesses of their cases, the effects of loss and the benefit of settlement, and whatever else is required to achieve a compromise. The mediator also enables the clients to be involved by being given the opportunity to speak and express a view in the course of the mediation, and to hear from the other side, the other client, the other party. The mediation enables the clients to be involved in the process. And then another important point to bear in mind is that the mediation is confidential. This means what is said in the mediation stays in the mediation. It cannot be relied upon in the legal proceedings unless the parties agree otherwise. And of course, the court order, if agreed, is a public document. And what is said between the parties and the mediator in private session is confidential between them unless agreed otherwise. Of course, and particularly in public law cases, the parties may wish for there to be some publicity, particularly at the settlement. They may wish to issue a statement to the press if there's been press interest. The settlement may involve a change or adaptation of policy, and others may need to be informed about that. So now I come to the procedure. And the procedure normally starts with a joint session of all those attending assembled. The parties introduce themselves. The ground rules of the discussion are agreed. The parties present their respective positions and at that stage can offer terms of settlement, though that is not usual. And usually the parties have previously exchanged prepared position statements. Then there can be some discussion, and then Generally, what happens is that the mediation breaks into private sessions and the mediator discusses the issues with each party separately and often takes offers and counter offers to each party. If agreement is reached, the mediator attends the drafting. All this is variable. That is also important to bear in mind. There may or may not be a joint session, or there may be a joint session, and then the joint session may reconvene at a later stage. It all depends on what will take forward the mediation process and how the parties wish to conduct the mediation. This process can last for half a day, 2 to 3 hours, or a whole day. And I'm not saying this is at all usual, but I once had one which lasted for 12 hours, from 9 in the morning to 9 in the evening. And now I'm going to come to what's on the screen. The practical steps. I've already hinted at these. Excuse me. First of all, the parties need to agree to mediate because mediation is voluntary. Secondly, they need to agree who the mediator is to be. And thirdly, they need to agree a location and a date for the mediation, and then prepare a bundle of essential documents for the mediator. This is not a trial bundle. What is necessary is for the mediator to have documents to know what the issue is, an idea of the evidence and the arguments in support. Offers of settlement can, in fact, in my view, should be included, and what happened to them if they've not been accepted, and cost summaries need to be attached also. That is, costs incurred to date of the mediation and the costs likely to be incurred in the future. Also, generally, the parties prepare separate position statements and also decide who is to attend. Obviously, the client, the legal representatives, maybe the client's supporters, and possibly, though this is comparatively rare, expert witnesses. And finally, this is most important. From each party, there must be a person with authority to settle the case. So finally, I am going to express some views on the suitability of mediation for judicial review. And here I am unashamedly quoting from my own blog on the Garden Court Team Mediation website in March this year on the review of the Possession Claims Mediation Pilot. And my conclusions were that in considering the introduction of mediation into a particular area of law, those concerned should start by considering what sort of cases are suitable for mediation. Do not start by assuming that mediation is suitable for all types of cases in all circumstances, or that it is there to solve particular problems affecting the courts. Secondly, those concerned should ensure that the mediation procedure adopted is one that will enable agreement. Is sufficient time for mediation, that the mediators are experienced, and that there be available legal advice for the parties. And thirdly, those concerned should ensure that the judiciary and the court staff are aware of the availability of mediation, the procedure adopted, and the pros and cons of its use. I hope that is helpful, but of course, it is entirely up to you.
Thank you, David. Thank you very much. We are already getting some questions coming in, but we'll leave the answers to those questions at the end. Next, we're going to turn to Margaret Doyle. Margaret, like David, is very familiar to people in the legal and mediation world. Margaret is as well as being a mediation member of Garden Court Chambers, she's both a visiting fellow of the University of Essex Law School and is a highly experienced mediator, where she combines her rights-based mediation practice with research that explores the role of Mediation and Ombudsman in Administrative Justice. One of the many projects she's been involved in was the Public Law Project work to carry out the first research into mediation in judicial review in 2009 and to 11. And she's a member of an academic panel of the Administrative Justice Council, the College of Mediators, and accredited under the SEN practice standards and certified by the Elder Mediation International Network. And in addition to all of that, she also finds time to write regularly for the Garden Court mediation team. So over to you, Margaret, and you're going to talk about issues of research.
Yes, thank you, Tim, and thank you, David, for that session on the practicalities of mediation and judicial review. As Tim said, I'm going to talk about research that was carried out in 2009, 2011, and this was, Tim has referred to a renewed interest in mediation and judicial review, and it's true that about 15 years ago, there was an appetite by the Minister of Justice to have more mediation and judicial review, and that was really the reason for the research being carried out at the time. The sort of trends and patterns of settlement that I'll be referring to are drawn from a report called The Dynamics of Judicial Review Litigation, which was by Barbondi and Morris Sunkin, and that was published in 2009. And I understand that figures, some things will have changed by since then, but I think the trends in terms of settlement will be very similar. And the other report that I'll draw on is one I was involved in, which was looking specifically at mediation and judicial review through an empirical research study. And yes, both of those were Public Law Project and funded by the Nuffield Foundation. The headline findings, I think, are important in the context of judicial review and mediation. Is that most potential judicial reviews are resolved. Most are resolved as a result of some pre-action letter. They might be settled or withdrawn or closed in some other way. As has already been referred to, a sizable number are resolved even before permission, so between that pre-action stage and permission. But then a large chunk are actually settled once permission is gained before a full hearing, a final hearing. Most settlements in judicial review favour the claimant, but a couple of things to say about that. I mean, one is that this could be either because the defendant either agrees to reconsider the decision or carry out the decision-making process in a different way, or they might actually agree some substantive service or benefit that the claimant was seeking that's at the core of the dispute. And it seems that this happens at the stage which the defendant lawyer gets involved. So for instance, after permission, it might be the first time that the defendant's lawyer has actually taken a look at the case, identify legal merits or not, make pragmatic decisions. So that's a key stage, and that's probably why we see a lot of settlements there. I'll draw on some quotations from the empirical research study on mediation and judicial review, which involved trying to understand where mediation was happening in judicial review and talking to lawyers about it. So some of the quotes I'll use are from that. But basically what it concluded is that the opportunities for mediation might be limited because we know judicial review is the remedy of last resort, and many options, many things will have been tried during the journey of the case through the judicial review stages. And as David has already alluded to, there's a tight deadline for action, so it might not be possible to mediate before seeking permission. And also judicial review as a form of litigation is relatively quick and straightforward compared to other litigation. And that's something to bear in mind in terms of where mediation might have a role to play and some added value. And as we've already seen, it already has a high rate of settlement with this sort of judicial filter of the permission stage. But those settlements may just be concessions in the form of quashing a decision, agreeing to reconsider a decision without delivering any substantive benefit really to the parties themselves. So we're going to touch on that in a little bit in terms of what's said about mediation outcomes. I just wanted to give you this visualization of the progress of claims through the judicial review stages. And this is a current visualization produced by Ministry of Justice in their most recent civil justice statistics. And you can see that, that as cases move through the different stages, there's a great falling away of cases. And they may be at a stage where, say, they refused permission or they're withdrawn. What the study in 2009 tried to do was really examine what was happening with those cases that sort of fell out of the system, and looking at to what extent those were settlements happening. And we haven't really had any sort of comprehensive research since then, but it looks like what we're seeing in the same sort of patterns. And you can see after the permission stage that a large chunk fall away, and those are often settlements. And settlements happen in a number of ways. So predominantly, most disputes generally are resolved through negotiation, and that in this case, it's directly between lawyers, negotiated settlements. But there's also a great use of roundtable meetings between the legal representatives, and clients are also sometimes part of that, sometimes not. And then there are mediated settlements at which, for the most part, clients, parties are attending themselves. And what we found in the empirical research was that a lot of lawyers said, well, what does mediation do the roundtable meetings don't do? So that's one of the things we looked at, what sort of added value. And one of the things interesting that was found is that because of the particular nature of judicial review litigation, unlike in other types of, say, commercial litigation, mediation isn't necessarily cheaper or faster than settlement or settlement by roundtable or judicial determination. And obviously that's a big claim that's often made for mediation, but it may not be relevant in these cases. There is this problem of the limited remedies that can be obtained in judicial review that can be ordered by a court. And that was cited by quite a lot of the interviewees in the study in terms of what their clients, whether that's a defendant or a claimant, might get out of actually a court determination. And so as we've seen, quite often a defendant's concession and a claimant's withdrawal of proceedings might just be a sort of pragmatic concession to retake the decision in a different way. Some of the common reasons that lawyers give for mediation not being relevant in public law, and Tim has already referred to this as well in terms of concerns about compromise or what's amenable to settlement in a mediation in a public law context, were pretty commonly expressed in terms of both the practicalities of judicial review and the urgency and the time limits. That a question of law needed to be determined, and really there was no room for compromise, or the case was so strong also that there's no room for compromise. The added expense of mediating was cited, the limitations on public bodies in terms of decision making, what could and couldn't be decided in a mediation context, and the power imbalance between an institution, a public body, and often an individual claimant. And as we know, these also apply in settlements as well. Quite often, several of these are as relevant in settlements, but they're not raised as concerns about settlement in the same way that they're raised about mediation. And we found that some of the lawyers that we interviewed had no experience of mediation, and so some of these objections were based on kind of common preconceptions or presumptions or even myths about mediation and what it does and doesn't do. Quite a few did have experience, and their concerns were well-founded and thought through. So I think it's important that we not dismiss these out of hand, but actually they're worth interrogating in a judicial review context and trying to see to what extent they are potential barriers. We've mentioned cost a bit, and I think David has mentioned that the specific context of the cost of judicial review litigation. And so what we found is that mediation isn't necessarily cheaper or even quicker than judicial review. But it depends a lot on when the mediation takes place, how much expense has already been incurred, how much the mediator charges. So all those sort of practical things that David mentioned. Also the importance of legal representation at mediation. And Helen's going to talk about the implications in terms of the costs of legal representation. I think all of us on this panel feel very strongly that it's really important that mediation in a judicial review context is not a lawyer-free zone, that parties are legally represented. And also I think that one of the aspects of that is to make sure that lawyers do have experience in mediation so they can help think through with their client whether or not mediation is suitable. Some of the interviews identify cost benefits that aren't easily quantifiable. So for defendants, it might be something like the costs of human resources, their own staff. There's a cost in attending mediation as well. But then there are other aspects that I think need to be sort of explored a bit in terms of better outcomes. So if mediation has a really limited role to play because of the specific nature of judicial review and the high number of settlements that happen anyway, what does it bring to the judicial review party in effect? What's its offering? And that's several aspects, but I picked these three really to focus on in terms of what the research found in terms of what the added value that mediation can offer in this context. And one is the guided structure that's overseen by an independent person with no personal interest in the outcome. So David's referred to the fact that the mediator is not a decision maker, not making a ruling, not telling people who's right and who's wrong, but offering a guided structure for doing that. That is client-centered. And the thinking is, we don't know this, but it's well argued that participation in decision making can contribute to more sustainable solutions and that are longer lasting and better outcomes, that the agreements can be more wide ranging. They can include actions, changes of policies and procedures, apologies, compensation even. And that one of the benefits could also be where there is an ongoing relationship, it might be in an education case or community care, that can be improved by parties working together in a mediation context. So I've just got a few quotes on each of these points to show you. So despite mediation being also described as an informal process, it does have a formal structure. And some of the interviews found that was really, really helpful. And particularly in a quite a messy case, or where you had a lot of parties in terms of the mediator being able to provide a safe sort of structure to hold the dispute. Some mentioned that you could get greater clarity about what had been decided or what had been agreed than you could from a roundtable meeting, because the mediator's responsibility is to make sure everybody's clear about what has been agreed before they actually leave the mediation. Interestingly, David mentioned about the structure of mediation, which is quite flexible and varies quite a lot, but some of the interviewees pointed out that they really didn't find shuttle mediation helpful. So that's when the mediator is moving between the parties following an initial joint session. Some of the lawyers described that as unwieldy and kind of time wasting. So I don't know whether that suggests that in this context, in order to get the full benefits of mediation, these added values, kind of retaining that joint meeting structure of the mediation would be quite important. The client-centered aspect was referred to in terms of the lawyer-centric nature of both judicial proceedings and roundtable conferences, and the clients are very often sidelined in that, and that can really make a difference in terms of how they feel about whether their issues have been addressed. It may also have an impact on the types of outcomes that can be achieved. And there's a question about whether individuals want empowerment, the sort of empowerment that mediation can offer. I know that some of the interviewees said that's not what my client wants. My client wants a decision. They don't want to be involved in the decision. They just want somebody else to make it. But I suppose that's a very individual aspect that would be important to explore with your client. To what extent do they want to be involved? And there is a certain level of reassurance in knowing that you have some say in what the outcome is. I mentioned about improving ongoing relationships, and I've certainly seen that in some of the special educational needs and disabilities cases that I do, which are not, they're rarely actually judicial review cases, but I have had one or two of those. And I think considering that that's a relationship that can go on for 20 or 25 years often, it's quite important to try to work on things like future communication and rebuilding trust in a relationship. And there's also a lot of flexibility in the way that the mediation can be run. So in our research, we identified some case studies where the mediator sort of went above and beyond to include a party who couldn't actually attend mediation in person by visiting them at home, for instance. And there are lots of ways that participation can be facilitated in either a direct or indirect way. And finally, this point of better outcomes, so that it was suggested that judicial review is really quite a blunt instrument. So it's important in determining a point of law, for instance, but there's a lot that a client might want or an individual party might want that couldn't be delivered by a court. So there are just a few quotes of people who thought actually the opportunity to have more wide-ranging, more sustainable, more holistic outcomes was a real benefit of mediation. And some of the solutions, this one barrister at the bottom suggested that some of the solutions that could be worked out in mediation might actually be cost-saving to a defendant body. And so there can be, it's not just the claimant's interests that are part of any discussion and possible agreement as a result of mediation. And also that even where a case isn't resolved, the mediation has broken a sort of deadlock and an impasse and helped then provide some more momentum to something being resolved or narrowing it down before it goes to the court. I'll just give a brief one of the case studies in the report was an example of where we called it the best of both worlds, because it was where mediation actually did provide an interesting, beneficial outcome that the court couldn't have provided. But there was a novel legal issue that had to be determined. And it was about the support package for a disabled young adult. And at the time, I think these were called independent user trusts. I think now it's part of a personal health budget, one way that support can be arranged and paid for either by the individual or their family or a trust. So at the time, this was considered a novel issue. This is what the family wanted, but the trust said it didn't have the power to establish one. They did hold a mediation before the final hearing. This was the one where the mediator actually went to meet with the young woman at home before the mediation, and it wasn't settled at mediation, but the arrangements were agreed should it be determined that the trust did have that power, which indeed it was ruled that the trust did have the power to set it up. The judge said judicial review is really an unsatisfactory means of dealing with cases such as this, but it was an example of where that formal judicial determination was needed, as well as the flexibility of a mediation process to work out the detailed arrangements. And another case study was very, very messy with lots of parties and lots of hostility. And I just thought this was a good illustration. Often mediation is suggested as a soft option for those cases where you've just got a little bit of something that needs to get worked out. But actually, what this barrister suggested was that it was because it was such a messy case that mediation was so beneficial in this situation, and the level of hostility and the deep-rooted hostility between the parties couldn't have been sorted out really without the help of a mediator. And I think both those examples, and there's a third one I think in the report, are good examples of where this combination of a process might be needed. And I think we shouldn't always see mediation as an either or. On the other hand, there will be added costs if you actually need to have both judicial determination and a mediation. But if you're looking at what's needed in that case to actually deliver the thing that the people need, it may be something to consider, to look, and particularly in those areas where we're talking about individual needs that Tim mentioned earlier, in terms of the sort of details of what kind of needs individuals have and how they can be met. And just finally, I want to say something about public interest, because David's mentioned it about confidentiality, and I do think we need to think about confidentiality differently in public law mediation than in sort of private disputes. And one of the areas that I work in special educational needs and disabilities, the mediation is confidential, the discussion, but the outcome is not. Now, it's not that the mediator goes out and disseminates the outcome, but it means that the parties themselves, if they need to, can share that outcome with others who need to know in order to implement the actions or to inform policy change, for instance. So there might be lots of reasons why it's important for us to think about sharing outcomes of mediation in a wider way, and also in terms of just scrutiny and accountability of public bodies. And about 20 years ago, CEDAR, which is a primarily commercial mediation provider, did a booklet on ADR for public authorities, and they made a really clear point about sometimes it will be undesirable to maintain confidentiality of outcome in a mediation that involved a public body. And I think that we haven't looked at that very much since they did that, and it's well worth trying to keep that in mind and explore a bit more how that would work in a practical way. All the reports are publicly available, freely available. The research is on the Public Law Project website. I've got links here as well. There was also around the same time a small bit of research on how local authorities use mediation in judicial review by Nabarro and 39 Essex Street and the ADR group. So I've added that as well in case that's of interest. So that's it for me. Back over to you, Tim.
Margaret, thank you very much. If you could just stop the screen share. We are getting a couple of questions coming in, but what we're going to turn to now is to Helen, who's going to finish up. Helen is a barrister and a mediator at Garden Court Chambers. She's a trained and experienced mediator, and quotes say that she has excellent interpersonal skills and an ability to keep focus on coming to an agreement. And also that she brings skills required in litigation, namely her energy, insight and stamina to effective use in the mediation process. I encountered Helen, first of all, when she was a criminal practitioner, and then she decided to evolve and become a mediator, and she now works in court protection work, and that she also regularly writes for the mediation team blog. Helen, you might want to switch your screen display settings on your PowerPoint, and I'll turn it over to you.
Thanks. Has that worked on the swapping it over?
Yes, yes.
Oh, good. Thanks very much. Thanks very much to David and Margaret. Thank you, Tim, and to David and Margaret for your presentations. I'm going to speak very briefly, 5 minutes or so, about costs. That's partly because judicial review mediations are rarely about money, even though there can be a component. I'm going to leave this question, is it cheaper to mediate than litigate? It possibly justifies a separate webinar, and some observations have already been made about it. It can reflect a party's enthusiasm for mediate, but essentially what has already been touched on is that mediation needs to be paid for. The mediator themselves require payment unless they're doing it pro bono, which some of our panel do on occasions. And also the legal representative needs to be paid to advise the party attending at the mediation whether or not the terms under discussion are ones which are suitable to resolve the issue. The government 2 years ago published a guide to civil mediation. There's a hyperlink here in the slide. It lists disputes which can be mediated. Sadly, it doesn't include a reference to judicial review, but that doesn't mean that judicial review matters can't be mediated. It doesn't include any reference to legal aid either. I make no comment about that. If the parties are privately paying, then each pays its fee separately and upfront, splitting the mediator's fee equally. And there may be a discussion at the end of the mediation about costs that have been incurred. We've heard mention of costs already. If there's a civil legal aid certificate in place for the claim, then the mediator's fee is claimed as a disbursement under that certificate. And it's at an hourly rate of £100.80 per hour. The fee that's advertised by some mediation providers looks as though it's a day rate or a half day rate or something like that, or a fixed rate. that can separately be invoiced to a legally aided party on the basis of the hourly rate. So the way in which the provider advertises itself doesn't need to be a bar to the fact that the mediator's fee is available to be paid as a disbursement. Prior authority is not needed to reassure you that the mediator's fee is there to be claimed as a disbursement. If the mediation takes place before permission and settles, then the cost of the work done is potentially payable at the legal aid agency's discretion. And anecdotally, this has rarely been claimed in my communication with the LAA, although they've said that they don't have any formal stats on this available at this current time. The attendance of a solicitor or barrister, although David has said counsel can be dispensed with, of course, but as Margaret said, the importance of having independent legal advice is significant, because without it, it's very hard for a party to assess whether or not the terms of settlement are ones that they really are engaged with and are prepared to sign up to, so that the settlement agreement becomes enforceable. But the attendance of solicitor and/or counsel can be covered under the attendance and preparation heading rather than advocacy, for preparation of preparing the party as well as attending at the mediation. Now, in communication with the LAA, they've said this would be an issue of reasonableness in terms of the cost assessment around whether it was reasonable to attend the mediation. That's not particularly satisfactory for people who don't want to and can't, for excuse me, very understandable business reasons, just excuse me, turn up and work for free for a day or two. It does suggest that there needs to be an assessment as to the prospects of settlement prior to the mediation, which could then be later relied on to justify the cost that's claimed. And that could be just effectively relatively straightforward merits of looking at the costs incurred, the cost if things don't resolve and it goes to a contested hearing, and whether or not, looking at the issues, there's a reasonable prospect of settlement being achieved at a mediation. So if there's something like that, then the suggestion is that it would be reasonable to incur those costs, and they will be recoverable when the bill is submitted. Thinking about costs, slightly wider context, what happens about them if the settlement has been reached on the substantive issue? A legally aided party, given the uncertainty at the moment of recouping those costs, or the sense in which they're not absolutely guaranteed, they may seek to recover their costs from the other party at the mediation, rather than risk the cost not being covered or in some other way being reduced or cut down on assessment. So a couple of points about this. Firstly, share, as has been said, share information about the costs that have been incurred to date, and the forecast of costs if you go ahead to a contested hearing. Share that information at least with the mediator, if not with the other party, although the mediator generally encourages information sharing about costs so that people can understand what's at risk. That does feed into Margaret's point about whether or not mediation is cheaper. But as I say, that's a bigger topic. If the party is successful in a contested hearing and they've unreasonably refused to mediate at an earlier date, they won't get their costs. The Court of Appeal has made that clear, as have successive judgments after it. So that's useful to know in advance of a mediation of where it's useful to spend money. So I think that I'm within my time. Tim will give me a yellow or red pen if I'm not. So the Civil Legal Aid Review is underway. It's due out next year, and just glancing at it, mediation appears within it. Whether or not it's there next year when the review comes out. And what it says about mediation, we'll have to wait and see. But it's looking at focusing on outcomes to encourage early resolution of disputes, providing swift access to justice through early legal advice and mediation. Well, let's see if it's funded, because without appropriate funding, it's very difficult to see how the appetite, which certainly the Master of the Rolls wants to encourage, is going to gain any traction. Master of the Rolls has said very clearly, let's call it ADR. It's not alternative, it's just dispute resolution. And there are a number of initiatives which it sounds like are going to be taken forward, and mediation is being pushed in inverted commas. So you may have heard about the Knotweed case at the moment, where there's mediation bodies are intervening in that case. So it's on the radar, and importantly, there are some principles of access to justice which need to be looked at. And so we wait really with bated breath as to what the review will say about legal aid next year. And I think that I'm going to stop there. Thank you.
Thank you, Helen. If you could just stop screen sharing as well. There are two questions. There are three questions posed, but Stephen Jones has, I think, put his name up twice. There's a question from CEDA International Law People's Tribunal, and their question is this: if both UK and international laws are on side victims calling for mediation and a government declines an offer to mediation, what pleas can victims do to lever settlement talks? And if the person who posted that wants to just open up their microphone if they want to add anything to that, please do so. But I invite the panel to see if they can come up with an answer. What levers can be used?
I'll take that for a start, Tim. I've got 3 points to make there. The first step is to have a real good shot at persuading the government to go for mediation, putting all the advantages of it that we've been talking about. And in particular, this is what Helen has touched on, the cost consequences of failing to agree to mediation. If the claimant succeeds, then the claimant can be entitled to apply for indemnity costs against the government. Taking the example that the questioner has put. So that's point number one. Point number two is that an application can be made to the court, and as the law stands at present, although the court cannot compel a mediation to take place, it can require the parties to consider the alternative of mediation. And the courts have taken pretty dim view of the kind of reasons that are given for refusing mediation, such as we thought we had a strong case or it was a difficult case. And the last point is the questioner has started a hare here because there is before the courts a case called Churchill and Merthyr Tydfil, which is going to be invited to rule on the question of whether a court can require the parties to mediate or not. There's a case against that. It's a case of Halsey, Halsey, which says that to do so would be a breach of Article 6 of the European Convention. But 3 of the mediation organizations, including the Civil Mediation Council, the CMC, have intervened in that case in order to argue that Halsey should be overruled on that point. So on the issue raised, it's a watch this space position.
Given that we've got a little bit of limited time and Stephen Jones has asked 2 questions. I'm going to address Stephen's questions first, and if there's anything that came out of David's comments, the other panel participants can deal with it. Stephen's asked 2 questions. The first one seems to be: the majority of my JRs are of decisions of magistrates' courts in criminal proceedings. Such courts regard themselves as functus officio, and there is a recent High Court authority that supports this view. This first question is: can mediation play any role in this area? And secondly, Stephen asks: in all my JRs, whether against magistrates' courts or against police forces, clients are legally aided. Will the legal aid fund extend the scope of a certificate to include the cost of mediation or arbitration? Without such mediation, arbitration will be a non-starter for my clients. I'm just going to say that I've had some limited experience in dealing with judicial reviews of both magistrates' courts and coronial courts, and generally my experience, at least with the magistrates' court, is that the magistrates take no part and you're dealing with the CPS. And secondly, with coronial courts, the coroner, if they're sensible, takes no part, you're dealing with the other interested parties. So I turn over Stephen's questions to the panel, if you can answer him.
I'd just say very quickly that I appreciate, Stephen, you've said that one of those questions has been answered on the cost thing that I was just talking about legal aid and what you can claim under the certificate. In terms of jails of magistrates' court, I think it's slightly difficult because potentially you might want bail, for example. So a mediator isn't going to be able to do certain things that you're looking for. So I think it would be a very limited role. That would be my view on things that involve the liberty of the subject, if that's the area.
My addition to the magistrates' court point for Stephen is that when I did one case that the magistrates took, it was a refusal to stay on an abusive process point in a youth court. The magistrates did not take any position, but the CPS, once permission had been granted, then effectively conceded that the magistrates were wrong, even though during the hearing they fought it tooth and nail. And then it wasn't through mediation, but it's through a lot of negotiation. An agreed position came forward out of the negotiation as to what the High Court ought to do, and to have the High Court endorse that. And it did lead through the negotiation for Surrey Police to reinvestigate or restructure their policies in respect of how they deal with youths and how they deal with their sort of sweeps to take them out of the criminal justice system. So there may be some residual role for mediation in terms of resolution between the other interested parties when the court itself takes no effect. But I think it would be much more limited in the criminal jurisdiction than within the civil jurisdiction, given the position of the courts and the limited powers even the High Court has in respect of dealing with some of the decisions of the Magistrates' Court. Does anyone else have anything to add? David, Margaret?
Well, Tim, you've given an example of what I was going to suggest as a possibility. I can see the difficulty here, because presumably in the cases Stephen's been talking about, the client wants the quashing of a conviction or the variation of a sentence. As what you've described shows, what that really involves is the prosecution conceding that those variations take place. So there's room for mediation there, but I agree with all of you that it's limited.
And also that you have the appeal route from the Magistrates' Court to the Crown Court, and it's only in limited circumstances of decisions that take it out of the appeals process that the High Court would have any jurisdiction.
Tim, I was just going to add on the first question and add to David's response on that the Ministry of Justice, their proposals to bring in mandatory mediation for civil claims specifically excluded claims where one party is a government body. And there's no further explanation about that, but I just think it's something to keep an eye on in terms of what their intentions are, particularly if they're pushing mediation in a judicial review context, how that fits up with the proposals on civil justice and mandatory mediation.
I'm just going to ask two questions of the panel, but they're kind of related. My experience as not as a mediator, but as an advocate, is that sometimes parties, you feel the other party goes through just the motion of the mediation, that they don't come to the mediation in good faith. And I just wondered what people's experience of that was as a mediator. And secondly, when you do have a position, as Margaret said, about not having the confidentiality of the outcome, I've been in circumstances where an agreed statement has been produced by both the claimant and the defendant in judicial review claims as part of the settlement process, even on a point of law. And because naturally the claimants can't determine that, those statements go to the court when there's an important point of law, particularly on the application of a policy. Have the mediators experienced that as well, for the court to endorse the view of the parties effectively? Have the mediators experienced that as well?
I haven't.
No, neither have I on your second point. On your first point, I have heard this taking place, that a party has attended purely to avoid any consequences of not agreeing to mediation, but I have never come across it in practice. I mean, every mediation that I've done, and I've been mediating about 15 years now, the parties have attended at least with some effort to come to an agreement. So of course that it doesn't happen all the time.
I was just going to say, Tim, that I know that we're over time, but there are still some people here. So I think that it has been said, when the invitation to mediate goes out by the other side, that all the other side is trying to do is fish and assess the quality or the solidity of the other side's case, and there isn't really an attempt to settle. And that can often be a question of timing of when the mediation takes place, so that if it is very, very early on, they're easy obstacles to put in the way. But a bit later on, when the evidence there's been a bit of a more of an assessment of the merits, then I think a mediator can do some reality testing, even in the pre-mediation discussion, as to really what's the true intention of the party who's proposing to come along to the mediation, and is it really going to be worth the other side paying for a mediation if it's not going to achieve anything. So some of the pre-mediation discussion that takes place can flush out or fine-tune what the intention is of the people who are going to attend a mediation or planning on attending a mediation. And I just must say, I hope I haven't done anything technically wrong. I tried to answer one of the questions from Alex Christian, and I think that hopefully I haven't deleted the question, but I've answered it within the Q&A. It was a question about the Churchill Knotweed case that and David just mentioned about the case with Merthyr Tydfil, and the question was asking whether it's relating to the internal complaints process, which I think it does, but it also does refer to whether or not the time has come to compel parties to mediate, which would lead to the overturning of the Halsey decision. I've just put the link in there from the Law Gazette article, which goes into it in some more detail. So I hope that I haven't deleted Alex's question.
No, that's happened. I mean, it didn't It didn't come through to me, but I've seen in the chat that you've answered that question.
Okay, thanks, Tim.
Well, thank you all for attending today. I hope it's been useful to you, for all of those who've managed to stick out, even though we've gone over time. Just as a little bit of advertisement, that we have other webinars coming up this month. We have one this afternoon at 5 p.m. on the Renters Reform Bill, and on the 25th of July at 5 p.m. on the need for lawful notice for eviction of travellers, and it's a case study. So thank you all for attending. You will all get a copy of the video and the slides sent out to you, and also that there will be an opportunity for you to give feedback on the webinar and its contents. So given that people are slowly leaving, there's a stalwart of about 70 still staying, but given where we are, and we're just about 13 minutes past 2, thank you all for attending, and I'm just going to draw an end to the webinar now. Thank you very much.